Okay, I think we will begin. Hello, welcome to today's virtual panel on understanding judicial ethics enforcement. Thank you all for being here today. My name is Miriam Seifter. I am a law professor at the University of Wisconsin Law School and faculty co-director of the State Democracy Research Initiative here. I will be the moderator of today's discussion. The State Democracy Research Initiative is a nonpartisan research program devoted to studying and promoting greater dialogue on questions that are too often overlooked in legal circles and in law schools, which is questions of state public law and state constitutional law across the nation. So I'm going to start us off by introducing our panelists, and then I'll say just a few words to situate their presentations. First, Bryna Godar is a staff attorney with the State Democracy Research Initiative here at UW, where she focuses on state institutions, state constitutional law, and election law. Bryna joined the initiative following a clerkship with Judge Jeffrey Howard on the United States Court of Appeals for the First Circuit. Before practicing law, she worked as a journalist in Wisconsin and Minnesota, reporting primarily on local and state government. Billy Corriher is the state courts manager for the People's Parity Project, which is co-hosting today's panel and which advocates for the power of ordinary people in the legal system. He worked at the Center for American Progress from 2012 to 2017 and has also worked as a freelance journalist whose writing has appeared in a variety of state and national outlets. Finally, Al Smith has been the executive director and principal lobbyist for the Montana Trial Lawyers Association, MTLA, since September 1997. He serves on the American Association for Justice's Committee on the Judiciary. Al is a recipient of MTLA's Public Service Award and AAJ's Partnership Award. We're grateful to each of our panelists for joining us today. So just a little bit more information from me before we get started with their presentations. First, just a bit of required housekeeping. This event was approved for 1 Wisconsin CLE ethics credit by the Board of Bar Examiners. We will conclude by 1 p.m. Central Time today. For those of you seeking CLE credit, I will announce the CLE passcode shortly before the conclusion of the panel. Please listen for that passcode and enter it into the Google form that will appear in the chat on the Zoom webinar at the appropriate time. In addition, time permitting, we hope to take questions from our audience after the speakers have presented. And to ask a question, please use the Q&A function on Zoom, not the chat, but the Q&A function to ask your questions. You may pose them at any time, and we'll get to as many as we can. Second, just a little bit of substantive context for this panel. The national conversation has paid a fair amount of attention to the importance of judicial ethics requirements at the federal level. A reason to have this panel is that these are issues at the state level too, but have seldom been studied. Every state has some sort of judicial ethics or judicial conduct commission, and year in and year out, they have played an important role in protecting the public from unethical conduct. At the same time, judicial conduct commissions can themselves sometimes create conflict or pose problems. Like any entity, they can, for example, be misused or restructured or co-opted for objectives that are not the public's protection. So the goal of this panel is to shine greater light on state judicial conduct commissions, both the important work that they are tasked to do, and also the ways that they can potentially go astray. For our opening remarks, we'll begin with Bryna, then Billy, then Al. Bryna will discuss the broad national picture, and Billy and Al will discuss recent examples from North Carolina and Montana. So with that, I will turn it over to Bryna. Thank you.
Thank you. So like Miriam said, I'm going to talk a little bit about the overall structure of judicial conduct commissions nationally, what they look like, what kinds of things they do. So these commissions are primarily designed to protect the public from judicial misconduct. And their role involves investigating allegations of misconduct and then recommending or imposing sanctions if warranted. And those sanctions can be anything from something like a private reprimand or warning letter to suspension or ultimately potentially removal from the court. So these commissions largely came about in the 1960s, 70s, and 80s in this major sort of national wave of reform of the judiciary. In the 1920s, the American Bar Association had published canons of judicial ethics, but those canons had no enforcement mechanism. So even though they were subsequently adopted by most state Supreme Courts, there was no method for enforcing those canons or addressing issues in which judges violated those canons. And so then in 1960, California established the first state judicial ethics commission, and then these proliferated in every other state over the next few decades. And they really stemmed from concerns about corruption, bias, and other misconduct in the courts. There were several high-profile scandals. For example, in Illinois, there was an instance where two state Supreme Court justices acquired shares in a Chicago bank right before deciding a case in favor of one of the bank's executives. And that really spurred reform in Illinois, and similar things have occurred in other states as well. So the basic way that these work is that they receive complaints from anyone, from citizens, from attorneys, other judges, and they sometimes get hundreds of complaints per year in a single state. The commission or staff members of the commission then have to screen those complaints, and many are dismissed at that stage, either because they're not actually a violation of the Code of Judicial Misconduct, or potentially they're raising an issue that should have been brought via an appeal of the court case as opposed to going to the Conduct Commission. If it is warranted, the commission then goes ahead with an investigation and might hold a hearing or might informally dispose of the case with the judge. And then ultimately, if it goes this far, they might impose sanctions or recommend sanctions to the state Supreme Court to impose sanctions. And the structure varies state to state. In 29 states, the commission itself cannot directly impose public sanctions. They have to instead recommend those to the Supreme Court. In others, the commission can impose sanctions, but that is typically subject to review by the state Supreme Court, with a couple exceptions. So these commissions also vary in how they are set up. So most state judicial conduct commissions are created by state constitutions. So 36 states have these commissions mentioned in their constitutions. 25 of those directly create the commissions, and then in another 9 states, the Constitution directs or allows the legislature to create a commission, and the commission is ultimately created by statute. In another 8 states and Washington, D.C., the commissions are created solely by statute, and 9 states have commissions primarily created by court rules and housed within the state Supreme Court. If you're doing the math, that's 51, so Oklahoma is counted in 2. It has 1 body created by statute and 2 created by its constitution. So that leads to another variation in how these commissions are set up. Some have a single body that both conducts the investigation and conducts the hearing phase. Largely that has survived due process concerns because of state Supreme Court review. Other states do it differently. They have a single body that splits itself into 2 panels, one that does the investigation and one that does the hearing, or they have multiple separate bodies. And that's what we have in Wisconsin, is the commission does one commission does an investigation, and then another body is constituted to do the hearing phase of the process. These commissions are primarily made up of judges, non-judge attorneys, excuse me, and public members who are neither judges nor attorneys. There are a few exceptions to that, but that's pretty consistent across the states that those are the primary categories of membership. The numbers vary pretty widely state to state though. And those members are appointed by a mix of appointing authorities. And here's where we see a lot of variation between the states. So most states use a mix of appointment methods, but the way that they're appointed varies widely. Some are appointed by the state Supreme Court, by the governor, state bar association, the legislature, or individual legislators like the House Speaker, for example, and then other judges or judges associations. Those are kind of the main appointing authorities. And most states do use some mix, but there are 14 states that have a single appointment method for every commission member. And that's most common in states where the commission is established by the court, and then the court appoints all of the members as well. So lastly, in terms of sort of overview of how these work, I'll note that a lot of the process is confidential. So all states provide for confidentiality during the investigation phase. and it only ends if the commission decides to prosecute the case, or in some states, only if discipline is ultimately imposed. So before getting into some of the concerns with these commissions, I do want to emphasize that by and large, they are doing good work. So members are often volunteers. The commissions might only have 1 or 2 staff members who are actually handling these hundreds of complaints that come in. And for the most part, commissions do seem to be doing a fairly good job screening out baseless complaints and pursuing investigations where they're warranted and holding judges accountable. That said, there are concerns that we see arise in various specific instances of how commissions have handled complaints against judges. And there are 2 sort of intersecting concerns here. On the one hand, there's a concern that commissions, with their confidentiality, are overly secretive and overly protective of judges, and that they fail to hold them sufficiently accountable or fail to impose severe enough sanctions when there are instances of misconduct. The other concern is that these commissions can be used for political ends to harass judges or secure favorable outcomes in court. And so the concern on the one hand is under enforcement, and on the other, it's sort of over enforcement or politicized enforcement. And so as an example of the first situation of concerns about the involvement of judges in this process obstructing accountability is Colorado. And so in the past few years, there were some serious allegations and findings of judicial branch misconduct, ranging from mishandling of a multi-million-dollar contract and allegations of a quid pro quo situation there, to sexual harassment and a toxic workplace culture. So I won't go into all of the details, but one of the things that happened during this investigation process is that the commission was alleging that the Supreme Court was intentionally obstructing and delaying the process, and that it was also threatening the commission's funding, and the commission was funded via the state Supreme Court. And so after this controversy and many months of these issues coming up, the legislature enacted really wide-ranging reform to the Judicial Conduct Commission to try to address some of these issues. And this reform garnered near universal support in the legislature, widely bipartisan. I think only 1 legislator objected to these reforms. And voters also approved a constitutional amendment a few weeks ago in Colorado to enact some of the reforms that the legislature had proposed that required a constitutional amendment. And those changes really did a number of things, but really tried to reduce sort of the outsized influence the Supreme Court could have and enhance the independence of the Judicial Conduct Commission and make sure that there were independent monitoring processes in place and independent processes for it to be able to do its work and do it well without the Supreme Court hindering that process. So that's sort of an example of the concerns with under enforcement and the court exercising improper influence. But something that we're seeing also on the other side is that in efforts to increase oversight of the commission or increase transparency, the structure of commissions is sometimes changing in a way that can allow them to more easily be co-opted by partisan actors. And so to illustrate how this happens is that these commissions wield major power. At the most extreme, they can alter the makeup of courts by suspending or removing judges or forcing judges to recuse themselves. That is often subject to state Supreme Court review, so it's not without checks, but they do have this pretty broad power. And even when they're not ultimately imposing sanctions, the actions of judicial conduct commissions can raise concerns about chilling judicial speech or intimidating judges via lengthy investigations that can also lead judges to rack up significant attorney fees defending themselves in those proceedings. And so the governor and the legislature, for example, are routinely in front of state courts. And so there's a concern that if those political actors have majority control over appointments to these judicial conduct commissions or have ways to influence what judicial conduct commissions are doing, then they might be able to unduly sway judicial commission actions in ways that are favorable to them by potentially pressuring judges or changing the makeup of state courts. And so as we think about how to set up these commissions in a way that maintains accountability for judges, we really also need to be thinking about how to insulate them from partisan influence. And I will turn it over to Billy.
Great. Thank you, Bryna. Billy, over to you.
Thanks so much, y'all. Billy Corriher with People's Parity Project. And I am in North Carolina right now. It's where I'm from. And we have a Judicial Standards Commission in North Carolina. And it works, I think, like the commissions in most states. They get complaints from the public about judicial misconduct. They investigate those complaints. And after the investigation and the judge has been given due process, the commission can recommend to the state Supreme Court that a judge be disciplined or sanctioned. And all of those proceedings are confidential unless the Supreme Court decides to impose some kind of sanction. The Supreme Court can remove a judge for incapacity or for misconduct. And the state Supreme Court even has the final say when it's a member of the state Supreme Court that committed the alleged infraction. It's kind of like what Bryna was talking about with Colorado. The state Supreme Court itself has so much power over this process. And it wasn't always that way in North Carolina. In 2013, our legislature passed a bill that gave the state Supreme Court the final say over whether judges face sanctions or reprimands. Before that, if the complaint involved a high court justice, then a panel of appellate court judges would decide what to do with the results of that investigation. And that obviously was a much better system because you don't have high court justices deciding what to do with their colleagues if their colleagues had violated the rules or something like that. And the confidentiality exists, to protect the judges because so many of these complaints are dismissed, and the judges don't want people thinking that they're, doing something shady if they're not, if they haven't even been given a chance to defend themselves. But the most recent ethics complaint that we've seen, at least in a public way, there was a real lack of confidentiality there, and it's really unclear what happened. But basically, about a month ago, 2 weeks before the election, 3 Republican state legislators issued a letter saying that they had asked the Judicial Standards Commission to investigate Justice Allison Riggs, who is a Democrat on our state Supreme Court. And Justice Riggs was on the ballot this year, and this letter came out just in time for early voting to begin. And in fact, Riggs's opponent, Judge Jefferson Griffin, had an attack ad ready to go where he, suggested or implied at least that she had done something unethical because she's facing this investigation. And this complaint alleged that she had violated the rules by talking about abortion rights on the campaign trail. She never talked about any case that was pending before her, but she did talk about reproductive rights. It's something that the voters obviously wanted to hear about right now. But we don't even know what the status of this complaint is right now. It seems like it was just intended to have a political impact. And you may have seen that the election was incredibly close. So something like this could really have an impact on the outcome. And this complaint wasn't the first politicized complaint that we've seen. Y'all may remember when Justice Anita Earls on our state Supreme Court faced a similar issue, I guess almost 2 years ago now. Her alleged offense was talking about discrimination and bias within the judiciary, a lack of diversity among the clerks, and also how certain advocates were treated when they argued before the court. She also made another comment about her colleagues on the court, or Republican colleagues, having a political agenda. And that's the kind of thing that we see a lot in a lot of these judicial standards complaints is complaints that either, a judge is sort of impugning the credibility or the ethics of another judge by saying that they're biased, or that they're talking about political issues, usually in a campaign context. in ways that violate the ethics rules. But in Justice Anita Earle's case, she actually waived the confidentiality requirement so that she could file a First Amendment lawsuit in federal court. And soon after she did that, the Judicial Standards Commission dismissed the complaint against her. However, she has said before that she is now running her public statements by the commission so that she doesn't get in trouble like this again. So this problem is definitely something that can happen again. In fact, Justice Earls is going to be on the ballot again in 2026. And given the structure of the Judicial Standards Commission, a lot of people expect that something like this can happen again in 26. We had a bill in our legislature last year that completely changed the structure of the Judicial Standards Commission. And right now, the way it's set up, there are only 2 Democratic appointees and there are 12 Republican appointees on the commission. 2 of those folks are appointed by the governor, who's a Democrat, and the rest are appointed by the Chief Justice or the House Speaker or the Senate Leader, all Republicans. 10 out of the 14 are judges. There are no lawyers on the commission. They don't allow lawyers on the commission, basically, because 10 are required to be judges and 4 have to be non-lawyers and non-judges. They took away the state bar's appointments, so they really don't like lawyers in our state legislature for some reason. And I want to go back to the state Supreme Court having such a big role in all this. Even when we've seen the Judicial Standards Commission doing a good job and trying to hold judges accountable for actual misconduct, it's up to the state Supreme Court what to do in the end. And last year, we learned that there were 2 judges who the commission had investigated in recent years. And one of these judges had basically started an altercation with the defendant, a verbal altercation that escalated very quickly and ended with the defendant shot dead by a bailiff in the courtroom. And this judge and the other judge both admitted that they had violated ethics rules. The other judge actually jailed a witness in a case so that they would appear. This person had to spend a few days in jail just because the judge was worried they wouldn't show up to testify. Clear violations of the ethics rules. And these judges admitted that. They didn't really try to argue that they didn't violate the rules. And the Judicial Standards Commission recommended a sanction. But the state Supreme Court disagreed. And if you ask me, the reason is because those 2 judges were Republicans and the high court majority right now is Republican. So all this would have remained secret if we hadn't learned about it from this ProPublica investigation. So on our court, it's not just these politicized complaints that are a problem. It's also inaction when there is legitimate misconduct. On our state Supreme Court, we've got justices who have heard cases involving companies that they own stock in. We've got one justice who has ruled on a few lawsuits filed against his father, who's the leader of the state Senate. And we've got a chief justice who gives campaign contributions to political candidates who are not judicial candidates. That's just a flagrant violation of the ethics rules, and he's done it a few times now. But there's no consequence for any of this because all those justices are Republicans. So unfortunately, what we've got right now is a clear double standard at work because one party controls the state Supreme Court and the Judicial Standards Commission. This means that members of that party can flagrantly violate the rules and they don't have to worry about facing any kind of sanction. But if you're a Democrat like Justice Riggs or Justice Earls, you have to worry about everything you say being interpreted as something that violates the rules. So this is not a new problem at the Judicial Standards Commission, I will say that. Like if you talk to Republicans who were around years ago, they'll talk about when Democrats controlled the commission, they faced similar problems. There's a former Supreme Court justice named Bob Orr, who is a former Republican now, but when he was on the bench, he was a Republican. And he faced charges also for some things that he had said that were interpreted as impermissible political statements. And he argues that when a judge faces these kind of investigations, they don't get enough due process He argues that the Judicial Standards Commission kind of predetermines the outcome before they start interviewing the judge and before they complete their investigation. And in fact, Justice Orr, when it came out, the complaint that Justice Earls was facing, he called the Judicial Standards Commission, quote, a vehicle for both political parties to try and use for political advantage. I wasn't around back then, but I will take his word for that. He's a very well-known judge, and I think he's probably got a point when it comes to some of these complaints. And I think a lot of this also stems from this kind of inherent tension between partisan, politicized elections and the rules that limit political conduct by judges. And if you read the comments to the rules, they talk about this tension, but our elections are becoming more and more politicized, more expensive. So we expect that these issues are probably going to keep popping up here in North Carolina. And if it does, the People's Parity Project will be there to speak out about it. And PPPR mission is to make the law work for working people. And part of that is ensuring that we don't have these kind of like politicized attacks on judges. Thank you, Miriam.
Thank you very much, Billy. And I would just note, for those of you here in Wisconsin, that in North Carolina, judges run in partisan elections. So the partisan affiliations that Billy was referring to are, in fact, the partisan affiliations that appear on the ballot in North Carolina. Al, over to you.
Hi, Al Smith. I'm in Montana right now. Thank you for allowing me to participate on this. So our Constitution provides for a Judicial Standards Commission. It's pretty straightforward. Two trial court judges, one attorney, and then two non-attorney members. And constitutional provision says the legislature shall set it up. And so what we had done up until 2023 is the Supreme Court appointed the two district court judges. After the district court, we don't have an intermediate appellate court, just district court, then Supreme Court. District court judges would submit members that were interested in serving on this commission to the Supreme Court. Supreme Court would choose those two. Supreme Court would also choose the attorney member, and then the governor would appoint the two non-attorney members. And it did set up basically what the commission was supposed to look at: willful misconduct, willful persistent failure to perform duties, and violation of the canon of judicial ethics. In 2023, the commission's makeup was altered in this way. The two district court positions now are, when there is a vacancy on the commission and they have, they're term limited, they have like a 4-year term on that. The two district court judges, when the vacancy comes up, district court judges are to submit to the Speaker of the House a list of judges who are interested in serving on this commission. The Speaker has then appointed a nominating committee within the House of Representatives with 3 members, including plus the Speaker, but as an ad hoc member. 1 member of those 3 has to be a member of the minority party. That committee then recommends the judicial member to the Speaker, and the Speaker can choose from the ones that were submitted by the panel or choose somebody else that he wants to. So it took it completely away from the Supreme Court and put it into partisan branch of government. The other thing is that the attorney position is now appointed by the Attorney General, not the Supreme Court. The one thing that remained the same is that the governor appoints the 2 non-attorney members. Now, we were in a little bit different position here in Montana in that we hadn't really seen any problems, allegations, against judges that weren't being fairly decided by the commission. And like many other states, our commission would make a recommendation to the Supreme Court. The Supreme Court would then decide what kind of punishment might be appropriate or none. And we really hadn't seen anything on that. What the commission had done is they had regular meetings. 90+% of the complaints that were filed were basically things that, the judge got it wrong, appealable issue type things, not that they had violated any ethics provisions. We do have a right to know provision in our Constitution. So even this commission, the decisions of the commission were publicly available. The complaint itself filed was not to be public, was supposed to be confidential to avoid what Billy talked about is, those complaints filed in the, first to last days of an election cycle to try and tarnish some judge that's running for election. Ours are nonpartisan positions in Montana. So with that transparency, not only on the website could you find this out, but the commission was required by their statute to make a report to the legislature every 2 years of all the cases they considered, their outcomes, and what the Supreme Court did with them. So it wasn't like anything was being hidden, and there wasn't anything that the commission did or didn't do that spurred on these changes. So the main reason for the changes is that we had a supermajority of one party in 2021 legislature, and they passed a number of bills that were unconstitutional. And legislature was told during public testimony that the bills were unconstitutional. They went ahead, passed them, and when they were challenged, a number of them were found by the courts to be unconstitutional, both at the trial court level and the Supreme Court level. And that's what really spurred the change in that for us in this commission, was that the legislature disagreed with the court's decisions. And again, the commission itself is not going to make any, that wasn't the problem, although they perceive that somehow that is the problem. So in the meantime, what they've done here in Montana is they set up a special select committee on the judiciary that has been meeting since April of this year as an interim committee. We meet every 2 years in odd years for legislative sessions. It was overtly political bill to go, or political committee to go after the judiciary. The minority party has declined to even participate in what they see as a rigged interim committee to do this. So they are proposing a number of changes to the Judicial Standards Commission. And some of the bills that they've come up with so far, and they are meeting again next week, so they're not quite ready with their pre-introduction of bills for the January start of the session. Judicial Standards Commission is under the Supreme Court right now, or the Court Administrator's Office, for administrative purposes. We have a proposed bill coming in that would remove that to another agency of state government. They haven't quite decided if it's going to be the Department of Justice, which is the Attorney General's office, or some thought Department of Administration, Department of Corrections, but they want to get it away from the Supreme Court, which I think has undue influence over the commission itself. One of the things they're also looking at doing is, I said that the filing of a complaint is confidential. The result of the commission's review is not confidential, it's open to the public. One of their proposed bills coming from this select committee is going to be specifically make it that a citizen, so that would be like a non-lawyer, non-judge complaint, but a citizen complaint to the commission would be publicly available. So get rid of that confidentiality stuff, which is going to set us up what Billy was talking about earlier. When the judicial election stuff comes around, somebody's going to file a complaint, and that'll be, hopefully they'll try and generate some headlines on that's what's happening here, is that this got a bad judge, they're being investigated by the Judicial Standards Commission. One of the other things they want to do is they want to revise the complaint process. They're not quite clear yet as to how they want to do that. Getting rid of the confidentiality provision is part of that. The other part I think is that has been talked about is to have the commission hearings themselves open to the public, which right now it's confidential. That may or may not be a bad idea. I'm not quite sure on that. The other thing that they're looking at too is to set up additional standards. I read earlier of, violation of judicial canons is one standard that the commission looks at for violations of ethics. They're also looking at setting up their own statutory standards of what would constitute a violation of ethics. They don't have the specifics out on that yet. That's one that could be good news, or it could be bad news. Part of it is, since it is a political process, I would expect that it's not going to be good news when the final draft is out and available to folks. The other thing along with that they're looking at is to revise the impeachment laws. So we do have, constitutional availability of impeachment of governmental officers, including judges. They want to change those impeachment laws. Again, they don't have the details as to, and the change would be, what amounts to an impeachable offense. And again, that could be a good thing, or more, from my view, from what I've seen in the past, probably a bad view of doing that. Because you could set up standards so that a judge would be constantly looking over their shoulder, worrying about the impeachment thing, rather than looking at a law and going, does that violate this particular litigant's constitutional rights, statutory construction, that type of stuff. So I think I'm glad we've got this commission. I think it's a good thing. I think it's good to have them transparent and have them public, so everybody knows what is happening with that. But I think to get away from the political nature of the review would be much better, to set up more of a nonpartisan process as to how things are going to be reviewed, and to provide more education. So that, so like I said earlier, our commission puts their results of cases up on their website. It's available for anybody, but nobody knew about it, including most attorneys. We had no idea that was available. But to have education on that, and I think part of it is education on the judiciary's part, for them to get out there and explain what it is that they do and what they don't do. But I think we're always going to be in this delicate balance that we have some way to review what judges are doing to make sure they are acting ethically. And if they're not, that there is some repercussion for that, and that the public knows that will happen. And more importantly, the judges know that will happen. They can't cross those lines without fear of consequences. I guess I would leave it at that for now. Thank you.
Thank you so much, Al, and thank you to all three of our speakers. I invite our webinar participants to submit questions through the Q&A function. And while I'm waiting for those to come in, I'll actually pick up where Al left off, which is with the question of possible reforms. So one of the benefits of studying 50 states across the country is that you have lots of data points and examples to draw from. And my question is, for maybe we can start with Billy and then Bryna. What else, Al mentioned education about the judiciary and how these processes work. What else is a sort of best practice that courts could adopt, or sorry, that judicial conduct commissions could adopt? What kind of reforms are advisable, and what would you recommend?
Well, it's a really tricky question. I mean, I think Alice sort of talked about the possible ways to prevent politicized complaints before an election. I would like to see some kind of rule where if the commission gets a complaint, I don't know, within a few months of an election and the judges on the ballot, they have some kind of expedited process for considering that complaint and reaching a recommendation. I think that would help prevent these kind of politicized complaints during an election season. And I think when it comes to like balancing transparency and confidentiality, that's really tricky. But I think we need a lot more transparency in our process, especially given the politicized nature of some of these complaints that we've seen lately. And when it came to Justice Riggs' complaint, there was never any confidentiality there for her anyway. So if we're going to have selective confidentiality, I think more transparency is kind of the answer. I like what Al said about how in Montana all of their resolutions are posted. I think that's something that would help the public kind of understand how the commission works here in North Carolina too.
Thanks, Bryna.
Yeah, so I think part of this is simply about norms. So it is hard to figure out exactly what safeguards to have in place that will prevent co-optation. And there sort of are no set of safeguards probably that can fully insulate against that, especially because state actors can change the laws. But there are, I think, a number of ways that these commissions can be set up to begin with in a way that insulates them to some degree. And so one of those is having these established in state constitutions and having the appointment processes established in the state constitution, which makes it much more difficult for legislators to come in and change those processes after the fact. They need a constitutional amendment to change it, which is certainly not impossible, but is sort of a slightly higher hurdle and requires buy-in from voters. And then on the appointments front, I think it's really important to have different entities appointing the commission members. So basically having no single entity have majority control over the commission membership, so that no single entity can have that sort of influence over what they're deciding. And this goes both to making sure that these are not overly protective of courts by not having judges appointing a majority of members, but also making sure that they're not subject to undue influence from, for example, the governor or legislators or the state bar. And so a lot of states do this already, but I think it's less than half of states have no majority appointment, no single entity with majority appointment. A lot of states do have a single entity or sometimes a joint entity with like the governor with Senate confirmation that controls a majority of appointments. So I think that's a major change that would be a helpful way of insulating these a bit more from co-optation. And relatedly, commissioners should only be removable for cause, I think, is another major protection here. And that is the case in a lot of states, but there are also a number of states, including Wisconsin and Texas and others, where when commissioners are appointed with a dual appointment method, so appointed by the governor and then subject to Senate confirmation, for example, the confirmation sometimes happens months or years after the appointment is made. And during that time, the member is essentially serving at will. So the governor can withdraw the appointment of that member, or the Senate can at any time, and has happened in Wisconsin, vote to reject that confirmation and effectively fire the commission member. And so in addition to having for-cause protection, I think one thing states could do is sort of close some of those loopholes in that appointment process to make sure that commissioners are actually serving with that for-cause protection and aren't subject to the influence from governors or legislators while they're actually serving on the commission.
Okay. One question that we have received is about how you find out information about either one's own state's ethics commission or whether there are any repositories for information about all 50 states' ethics commissions where a person could go to kind of compare and contrast. So maybe if Al and Billy, you don't mind quickly just describing what information is available sort of as an example about the commissions in Montana and North Carolina. And then Bryna would love for you to briefly describe the white paper you've written, which does collect 50 states worth of data. And maybe we can even get that in the chat somehow.
Yeah, so in Montana, you've got constitutional and statutory authority, and like I said, you have a website on that of where you could look those things up. I didn't think about that. I'll see if while somebody else is talking, if I can find the link, and I'll put in the chat so folks can take a look at that part of it.
Yeah, and I'll I've mentioned that in North Carolina, there's not a lot of transparency, so we don't really have anything like that. I will say the National Center for State Courts has something called the Judicial Conduct Reporter. Comes out every few months, and I think they look at advisory opinions and decisions involving judicial ethics and violations of judicial ethics rules. And I get an email from them every few months where they kind of like run down a list of like, this judge did this bad thing, this judge did this on social media, this judge had this conflict of interest. Yeah, so that is that's a good source for like information as it kind of comes out.
Great. And Bryna, do you want to tell us about your white paper?
Yes, so I also just put in the chat the Center for Judicial Ethics website generally, which does the Judicial Conduct Reporter that Billy was mentioning, and they also have other resources about state judicial conduct commissions. And then I also, Evan has put in the chat, published a white paper on state judicial conduct commissions last summer, and really tried to provide a pretty granular mix between granular and overview of how this works in all 50 states. So kind of diving in much more depth than I am able to go into in this presentation today, into the breakdown of how states handle appointments, the number of members and type of members on each state's commission, how these commissions are created, confidentiality processes, and a lot more information. So feel free to check that out.
Great. Thank you all. So it is now time for me to share the CLE passcode. So I will do that. Today's passcode is SNOW, SNOW, and case does not matter. Today is our first day of lovely snow here in Wisconsin. So that is SNOW, SNOW. There's just been put a Google form in the chat. And all you need to do is complete that form with the passcode SNOW by 8 p.m. today to receive your Wisconsin CLE credit. One more question that we have, and I think we have time for one or maybe two more, so please feel free to continue to submit them, is about the ethics of publicity of an ethics complaint. So, if someone is filing a complaint, or if someone is on the other end of a complaint, are there ethics standards that govern their ability to share that information? I know you talked about confidentiality, but could someone actually be subject to more ethics enforcement for sharing information, either that they have filed one, so that would be attorney ethics, or that they have been on the receiving end of one?
So generally, it depends on the state. In some states, the confidentiality only binds the commission and staff members. But in others, it also binds the complainant, the judge, the witness, and anyone else involved in the proceeding. I'm not 100% sure what sort of the consequences are if you violate that confidentiality. But that confidentiality has sort of largely been upheld. The US Supreme Court has held that states cannot criminalize the publication of truthful information about investigations by third parties or strangers to the investigations. Like if a newspaper gets its hands on a complaint, it's free to publish it and the state can't criminalize that. But state courts have kind of divided, or courts, sorry, have divided on whether that prohibition on the complainant disclosing the complaint violates the First Amendment or not. So largely those seem to be upheld, but there is some divergence on that.
Great. Oh, Al, did you want to weigh in?
Yeah, I know in Montana, the commission's been asked about this. What happens if somebody violates your confidentiality rules? And they said, well, it's never happened, but we have in our process something essentially like a contempt of court type proceeding on that. But it's never been used, so I'm not sure how that would come out. And I guess to the original question that was posted there, I haven't seen that it's attorneys that are doing this, and I think attorneys would have their own ethical standards that they'd have to worry about if they, if they were filing a complaint as part of the gamesmanship. It's close to a Rule 11 violation, I would think, of if you're filing a complaint that has no basis on doing that. But overall, I don't know that. I think the First Amendment would win out. If it really came push to shove, I think the First Amendment wins out and you could publicize the filing of a complaint. But like I said, attorneys are going to have that special ethics concern they have to worry about themselves.
Right.
Yeah. Just jumping in on that last point quick is largely complainants aren't penalized, don't seem to be penalized if they file unfounded complaints. Some states do, you still have to sign under penalty of perjury and various things. But where you do sometimes see discipline is of attorneys who file complaints that include misinformation and have violated their attorney ethical rules in some way.
Thank you. I think we have time to conclude with one more. And so maybe this question kind of brings us back to some of the tension that all of our speakers have discussed and that Bryna kind of started us out with. So some of the recent questions that we just addressed were focused on the problem of commissions that have gone astray or that have gone in the direction of politicization. But one of the points that Bryna started with was a longstanding worry that actually commissions will be too lax, that they'll be too influenced by the courts themselves, and that they won't actually be a safeguard against unethical behavior. So maybe we can conclude with, again, looking across the country, what are some design choices that can ensure that judicial ethics commissions are strong enough?
Well, Miriam, I will just jump in and say, I think for North Carolina, a really important step we should take is just removing the state Supreme Court from its paramount role in the process when it comes to complaints against high court justices. I think that's just a clear, I don't want to say conflict of interest, but it's sort of a conflict of interest when you have to decide whether someone that you work with, every time you come to work has violated ethics rules and should face some kind of sanction, up to like removing them from their position. I think that's the biggest. I think that's the biggest improvement we could make in North Carolina. And I don't know how well things were working before that change, before the Supreme Court kind of got this paramount role for itself. But I didn't hear much about what was going on in the court before the state Supreme Court got the final say. So I think that would be a better setup for how the whole process works.
Yeah, I would just say transparency. Having the transparency there so that if the public wants, they can find out what's going on, that it's not hidden. I think the other thing is to have clear standards that are there. And it's like our Constitution says, violation of the judicial canon of ethics. Those are pretty clear. So I think I'm really fearful that as our legislature looks at trying to set those standards and make them different than the canons of judicial ethics, I think that provides too much ground for mischief making. But I think having clear standards that everybody's aware of would go a long ways in the transparency. What happens? Complaints filed, decisions made. What was the decision? I don't know. I understand Billy's concern. I would think that if there was a complaint against a Supreme Court justice and the Supreme Court is the one that's going to make that decision as to what the punishment might be, or whether they're even going to uphold the commission standards, I think for, again, the transparency and for the public perception part, there should be a process to get away from the Supreme Court making that decision, whether there's a panel of other judges, a panel of judges and attorneys. I think it should be within the legal profession still as to making those final decisions on what the sanctions might be or on that. But I think it would be good to have something besides the Supreme Court hearing about each other.
Thank you. Bryna, you want the final word?
Sure. Yeah. Yeah, I agree. I agree with most of those points. And I think judges should continue to be involved in the process and beyond the commission because they uniquely know what judges are going through. But I think, again, judges should not be a majority of commission members, and judges should not control a majority of commission member appointments. And then I think also a piece of this is continuing to, like Al mentioned, continuing to increase transparency around these processes in a way that allows for members of the public to hold state Supreme Courts or commission members accountable if they seem to be under enforcing or if they seem to be over enforcing, and just giving the public more of a window into what is happening.
Okay. We are out of time, so this concludes our panel. Thank you so much to our panelists for speaking today. Thank you to you all for joining us. If you have feedback, we welcome that by email, and we look forward to seeing you at a future event. Thank you.